The final means of alternate dispute resolution that we're going to talk about is mediation. Mediation uses a neutral third party to resolve disputes in an informal procedure. Mediation is designed to facilitate an early resolution of the dispute. Mediation really caught on starting in the 1990s and certainly going through the 2000s. And the belief was that parties oftentimes are not served best by a long, lengthy litigation, but instead would be better off if they simply sat down and negotiated a resolution between themselves. This assisted negotiation. And the idea was everything is going to be win-win. This is good for both plaintiffs and defendants. And so generally now, virtually all disputes are going to be subject to mediation, meaning if you file a lawsuit, even in the absence of a mediation agreement, the court at some point is likely to order that case to mediation. The court wants the parties to resolve the case between themselves, if at all possible. So generally, all disputes are now subject to mediation. And this may be a result of an agreement for mediation. There may be an actual clause, or it may simply be the result of a court order of this mediation before trial. Courts don't want to go through a long trial process if the parties are able to work it out beforehand. A court always wants to move its docket. That's the most important thing to a court. Now, there are advantages to mediation. And as I said, for a while there, everyone thought that all disputes are going to be resolved through mediation. And the advantages, there's a lot of them, starting with the idea that it's confidential. It's private. When you file a lawsuit, everything you put in that lawsuit is generally public information. So if you're going to make an argument about pay, for instance, your salary is going to be in the lawsuit, and that's going to be, everyone's going to be aware of that. Your employment agreement is going to be public knowledge. Anybody can go look that up. But with mediation, it's private, it's confidential. And the only person that is aware of that information is, other than the parties themselves, is this neutral third party who is sworn to confidentiality. It's also inexpensive, relatively inexpensive. Most mediations are resolved within a half a day or a full day. So there's not a huge time commitment. And the parties are able to work things out without the cost of discovery or trial prep or actual trial procedure. It can be very inexpensive to mediate a case. One of the big advantages of mediation, and every mediator will tell you this, is that in a mediation, the parties control their fate, meaning this is the only time when the parties get a say in how much they're going to get or not get. So there's a sense of control in a mediation that is absent in an arbitration or a trial, that in a mediation the parties can decide for themselves. They can control their fate. And a mediation agreement, once you reach it and the other side decides not to follow through on the agreement, you can bring a claim in court based on the mediation agreement, meaning we don't have to talk about any of that underlying dispute. Instead, I simply take the mediation agreement to court and say, Judge, enforce this. Force this person to pay. So I can enforce that mediation agreement by going to court. So yeah, a number of advantages for mediation. And we all thought mediation was going to be the wave of the future. Unfortunately, however, oftentimes mediations are not successful. And one of the reasons for that is mediation relies on each party having a good faith desire to settle the case. Meaning, if you go into a mediation knowing that you won't accept any amount of money for your claim, or conversely, if you're an employer, you're not going to pay anything on this claim, that's going to mean that mediation is going to be a waste of time and a waste of money. So mediation only works if the parties want to mediate. And as I said, oftentimes parties are ordered to mediate by a court and therefore have no real interest in resolving the matter. It becomes just an expensive delaying tactic. Mediation also has problems in that there's no independent means for the discovery of evidence, meaning if I want to obtain records from my employer, I can't do that in the context of a mediation. I got to go file a lawsuit anyway. And if I file a lawsuit and I have to go through those steps, then why should I bother with mediation? Enforcement of a mediation agreement also requires court intervention. It's great that we can do that, but it also means that I don't have an independent means of enforcing this mediation agreement other than going to a court where I could have started to begin with. And of course, one of the other factors that I feel is important is that when we resolve disputes privately, whether through arbitration or mediation, what that means is those disputes, the information from those disputes gets locked up in a walled garden, and the rest of the world is unable to know what the result was. The common law, the idea of the common law is based on the idea of building on past decisions. And if you sweep all those decisions off of the table, then that means there's no ability for the common law to grow, to change, to adapt. And that's bad for society. So in conclusion, we know that employment disputes are increasingly resolved in private processes. Arbitration, a formal means of alternate dispute resolution, and mediation, we're using a neutral third party to facilitate a negotiation. Informal procedure. Arbitration is binding, mediation is non-binding. Make sure you know those things for your test.